All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. First case for the day is Westphal versus City of St. Petersburg. You may begin.
Your Honors, may it please the Court. I am Richard Sicking from Coral Gables for the petitioner Bradley Westphal. With me today is co-counsel Jason Fox from Clearwater. Bradley Westphal was a firefighter employed by the respondent, the City of St. Petersburg. And in December of 2009, he was injured fighting a fire fairly severely. In the 2 years that followed his accident, he had 3 surgeries, 2 to his back and 1 to his knee. The third of the operations was a total lumbar fusion just some months before the 104-week anniversary of his date of accident. He was totally unable to work during this period of time, and so he was paid temporary total disability. But at 104 weeks, it stopped. And the reason it stopped is because in the original workers' compensation law of 1935, there were 350 weeks available for temporary disability, and in 1991 it was reduced to 260 weeks, and in 1993 to 104 weeks. He filed a claim for additional total disability, which the trial judge denied, and then he appealed to the First District Court of Appeal and, among other things, argued that the 104-week limitation on temporary total disability was inadequate in terms of access to courts.
At 104 weeks, the temporary benefits stop. No one in the state, no matter how injured they are, can get temporary benefits beyond 104 weeks. But as to the way that the First District interpreted the law before this recent case, what were the options? In other words, what else was available to Mr. Westphal?
At that point, there was only one option available, and that was for the benefits to stop, because the district court had earlier in a decision, Matrix Employee Leasing versus Hadley, decided that when the legislature wrote 104 weeks, they meant 104 weeks and it stops, and he would have to wait until he actually factually reached maximum medical improvement, and then benefits could begin again.
That's what I was trying to say. Even if he, if a doctor had said at that point, even though he hasn't reached maximum medical improvement, he still will be permanently disabled. What would have happened then if the workers' comp judge had accepted the testimony of the independent examining doctor?
Well, if he had believed some of the evidence which he did not believe, that he had reached maximum medical improvement, then he could have awarded PT.
No matter how well he got, he was still going to be permanently disabled. In other words, he could get better with his back or his leg, I mean, if that was the testimony, but no matter how bad it was, he was going to be permanently disabled. What would have happened then? Then
the judge could have awarded permanent total disability, but he did not believe that, and that's his option.
But that's one option. What other, was there any other option available? In other words, if they had said, well, he's not at maximum medical improvement, but he's going to be 50% disabled, what would he be qualified? That's what I'm trying to find out about this gap. Was there any other options in order to avoid the gap of getting nothing until you reach maximum medical improvement?
Well, there is a curiosity here, and that is the statute requires the doctor 6 weeks before maximum medical improvement to rate the permanent impairment, even though the employee has not reached maximum medical improvement, and theoretically that's impossible. But he does get ratings, and they did pay impairment benefits, but that's less per week, and also it only is some of the weeks involved. It would not fill the whole gap. And not everybody is gapped, of course. Some people, when they reach maximum medical improvement, in fact, weeks or months later, might return to work. It isn't just that everybody becomes a permanent total.
Of course not.
But in this case, your client did, in fact, do something prior to the end of the 104 weeks, correct? Did he, in fact, attempt to get to show the, I guess, the administrative law judge that he was, in fact, totally disabled?
He tried, but the trier of fact did not accept that.
I understand that, but I'm saying he did that, and this was prior to the expiration of the 104
No, it was
weeks.
after.
It was after the 104 weeks.
Yeah, you can't claim something until you're...
The administrative law judge did not accept any kind of disability on his behalf.
That's correct.
Is that what happened in this case?
That is correct.
So why, oh, go ahead.
If I understand correctly, the statutory scheme, is it possible for the judge to declare someone to be permanently, totally disabled without reaching maximum medical improvement?
No. Previously, the district court had grappled with that when they first got the 104-week problem. And in the Oswald case, they held that if the employee could prove that in the distant future he would be a permanent total, that the judge could award the permanent total disability prematurely. But then in Hadley, they withdrew from that because it didn't work. Nobody had ever been able to do that. That's too difficult.
So hypothetically, if I fall off the roof and break my back, I'm not permanently totally disabled yet, according to my treating physician, and my 104 weeks runs out until I declare MMI. What options do I have? Whom can I appear in front of? What court can I argue a case in front of us? Administrative judge, workers' comp judge, anybody. Is there anyone I can appear in front of to plead my case? That I can't work and I can't get out of bed, electrical company's cutting off my power, I'm not getting any salaries, my children are starving, whatever. Who can I argue that before?
According to the district court in Hadley, it's over. You have to wait, no matter how long it is.
Until I reach MMI?
Yes.
And that could be how long? A year? 2? 6 months?
Whatever it is, which is why they came up with what the majority came. The panel decision was that the 104 weeks is inadequate, and then the temporary total disability would continue. That's the very simple and straightforward solution.
I thought the panel was, they found it unconstitutional.
I'm sorry, what?
I thought the panel decision in this case had found that the gap was unconstitutional because just as Justice Labarga said, once that 104 weeks ends, until you reach maximum medical improvement, you have no right to any benefits.
Only under the statute. The question is that adequate in terms of Kluger versus White? You held in Thompson versus the...
Did the panel decision not hold the statute unconstitutional as applied?
As applied, they held it was, the 104 weeks was unconstitutional as applied.
Now, why is it that you don't like the statutory rewrite of the First District in Westphal? Doesn't that give you, your client, what he needs to until he reaches maximum medical improvement?
No, first of all, the city has cross-noticed that he's entitled to nothing, that it's 104 weeks, it's 104 weeks, it ends, it ends, it ends. And beyond that, all the court said was that he was entitled to claim it, not that he was entitled to receive it. And of course, the trial judge had previously denied it not only legally, but also factually. So that's very dangerous. No, that was not exactly a win by any manner of means on that account. But certainly that's the posture of the case today.
But you can't win factually here.
No, I understand that. That's why it was dangerous. The fact of the matter is the 104 weeks is inadequate. When you decided the Thompson case, well, your predecessors, when it was 350 weeks, you said 350 weeks was inadequate. And you commended to the legislature that they should increase it, which, by the way, would correspond to the rest of the United States, because there are only 2 states that have 104 weeks.
Even though you say 104 weeks is inadequate, and I totally agree with you in circumstances where someone is still disabled and can't, but they haven't reached maximum medical improvement. But how does the fact that it's inadequate actually make this statute unconstitutional?
Only the portion of it. Clearly this court has the power, and you did this in the Smith case with the Tort Reform Act, to look at a single severable provision of the workers' compensation law or any other tort statute that compares with the 1968 remedies that existed at that time, and if it's inadequate. And if you believe that it's inadequate, and 104 weeks is inadequate, you've said that before, then that little number, 104, can be declared to be invalid as applied.
But
So
it's
what
not-
was the basis for reducing it from, it was previously 260 weeks, wasn't it?
Yes, it was
And so what was the basis for reducing it from the 260 to 104?
You mean, why did the legislature do it?
Yeah, I mean, was there any reasoning in the statute, any legislative history, what?
Well, there was supposedly a cost crisis, you see, but that disappeared, at least in this century, because in 2009, when they considered the amendment to 44034, the House staff reported that the premiums were now down more than 60%. The panel decision showed an insurance report that was down 56%. So there's what you said in McCall, a crisis is not permanent. And even if there were a crisis at that time in cost, it simply doesn't exist anymore.
But the
it hasn't
issue
for a
isn't
long
whether
time.
it's we don't make a judgment. I mean, the whole workers' comp scheme, from any rational, looking at it, is not adequate for somebody that's severely injured. They don't get the kind of money that, you would think would be reasonable, but that's a legislative choice. So what takes it from that it's inadequate to it's unconstitutional?
Okay. When the people voted for access to courts in 1968, they knew what the workers' compensation law was, what the remedy for employees injured at work was, the 1967 workers' compensation law. If you compare the 67 workers' compensation law with the current law, everything has been taken away.
But now you're saying, you told Justice Quince that you just wanted us to look at the 104. In your brief, you go and explain the whole scheme is inadequate. So you're now saying we have to look, in order to hold it unconstitutional, at the whole panoply of benefits or lack thereof. So can you explain that?
Yes, I'd be happy to. I was asked the question only about the 104 weeks. The fact of the matter is, in all the previous cases in which you've dealt with changes in indemnity or reductions in indemnity, you always went on to say, but we have full medical. We don't have full medical anymore. We now have major contributing cause in which people have compensable accidents, but if they can't prove that the accident was the major contributing cause of their need for treatment and disability by expert medical opinion, excluding lay evidence, that's the statute, they get nothing. Now that's certainly inadequate, and the people who have more than 50, can prove more than 50 but less than 100, they have to pay for some of their own medical expenses. That's not a workers' compensation law.
You live the life of workers' compensation, so got to slow down here.
Okay.
I thought you said that all you're attacking at this point is 104 weeks. But now you're saying, in order for us to decide whether the 104 weeks is unconstitutional, we've got to look at every other aspect of this statute to see that there is nothing adequate about the statute. So can you explain
No, there
that?
are obviously alternatives. One was the narrow view of the panel, which is 104 weeks is inadequate because you said in the Thompson case it was inadequate. It's inadequate compared to what everything else in the United States does, which is more than that, except for one other state. And it just doesn't make any sense. It would be just as inadequate if it was 10.4 weeks. 104 weeks is not enough. But
Well,
in
as
the
applied
past,
to this case, though, not totally, as applied, unconstitutional as applied to Mr.
This
Westphal.
case, that's
so
the
we're
narrow
not
view.
declaring if that were to happen. It's not that it's only inadequate because of Mr. Westphal's specific situation.
yes.
If I hear
However,
if I hear you correctly, I think what you're saying is that the benefits should continue until your client reaches MMI.
That's what
No
would happen.
limitations at all. No 104, no 260 weeks. They should continue until he reaches MMI. And then he's in a position to argue whether or not he's PT or not. But until he's MMI, what you're saying, I think, is there should be no gap at all. I guess that's the best way to say it.
There should be no gap, whether somebody is PT later or not, because 104 weeks is inadequate. That would be an unconstitutional amendment as applied to each case in which that occurs, and that would mean the 260 limitation, which is enough, at least in this case, would be the applicable law because the amendment would be considered unconstitutional. The point, however, was that in all the cases dealing with reductions in indemnity, like 104 or anything else, you always went through the explanation that that limitation was okay because it was a matter of the greatest good for the greatest number of people. But we don't have that anymore. But we have the least good for the greatest number of people because it's nothing but takeaways. The law, as the people, access to courts is not supposed to be bait and switch, where we get the people to vote for access to courts knowing what the workers' comp law is, and then the legislature takes everything away so that it doesn't resemble that anymore. That's inadequate. We don't have a Workplace Safety Act anymore. That's incredible. We don't have full medical anymore. That's incredible. We used to have, for the blind, the amputated, and the paralyzed, they got compensation for life. Now it's cut off at age 75. What are they supposed to do after that? It's section after section after section. If you compare them, you will find no comparison to the 1967 law.
Explain
you
to
will
me
find
what,
it on none.
assuming that you don't want a gap, what exactly is your concern with Judge Padovano's position that you reach MMI as a matter of law once the 104 weeks expire? What is your problem with that?
That's the certified question. And the problem is that was their interpretation of 440.15.2a. Now, there's two ways you can look at this. They viewed that as creating statutory maximum medical improvement, that the legislature decreed as a matter of law that all employees reach maximum medical improvement as a matter of law at 2 years. Well, that has no basis in fact, and it's contrary to the facts of this case, and there's no opportunity to rebut it with the truth. So that's...
But isn't it, they're trying to make constitutional what otherwise wouldn't be. Isn't that part of our statutory construction?
Not if you make it worse. First of all, the
how
colleagues said that they violated
the
separation of powers to create a category
how
of disability.
How is it worse as it pertains to your client?
Well, it doesn't work very well at all, because all he would be able to do is go back and claim and try to show they convinced the judge that the judge was wrong before in finding that factually he had not. That's a dangerous situation. You know, we're back to that.
But would he have to do that? It seems to me that under the majority opinion, if he has not reached maximum medical improvement at this 104, I mean, if he is presumed to have reached it at this 104 weeks, if he's still disabled. I thought that was the point of the majority opinion.
Yeah, but how does the legislature determine that? But if you decide...
Well, I mean, I'm talking about the opinion of the first district,
yeah,
not what the statute says.
Well, that was their interpretation of the statute, because nobody made before, that the legislature has made everybody get as well as they're ever going to get at 2 years, and based on the requirement that the doctor do something impossible, which is rate the permanent impairment, even though it's not permanently determinable at that 6 weeks earlier, then the employee can claim permanent total disability at that time. It's not that. They gave it a new name because it's a new category. Temporary permanent disability, and the statutory requirement that the people who are not blind, amputated, or paralyzed must make a work search doesn't apply. They only have to show that they're totally unable to work at that time, and we're going to explode the world into PTs. Judges are not going to be doing that, handing out permanent total disability willy-nilly, and carriers are not going to be paying it. This is totally unrealistic. But so the question recurs, the 104 weeks is inadequate. I think you have a choice of either the very narrow interpretation that 104 weeks is inadequate, in this case is applied, or you have to look at the whole picture and see that everything is inadequate, and I see I'm into my rebuttal time. Thank you very much for your questions, and I'll be back. Thank you.
May it please the court, my name is Kimberly Perano and I represent the employer self-insured in this case, the city of St. Petersburg. I'll be focusing on the first ECA en banc decision, and I'd like to point out that all the parties are in agreement that it's referenced as Westphal 2, the en banc decision, that all the parties are in agreement that Westphal 2 is the incorrect interpretation and that the Hadley decision is the correct one. Where the parties differ is that Mr. Westphal believes that the Hadley decision renders the statute unconstitutional.
Question on the statutory interpretation. I'm sure the majority of the first district feels very badly that no one here agrees with them, but what is their reasoning was that 6 weeks before the 104 weeks expire, so that's some period of time before, an impairment rating needs, what is it called? What has to be done 6 weeks before?
It's the impairment rating for permanent impairment benefits. However,
Okay, so what they were determining is that what is the purpose that the legislature would put that provision in if it weren't to make sure that there was not a gap in the benefits that someone received? I think that's how they came up with this. What is the meaning of it then? If under the circumstance that unless someone's permanently disabled and has reached maximum medical improvement, it means nothing. So what is your response on that?
my response on that is that the impairment rating is not the same as disability. What they are doing is allowing, not at the end of 104 weeks what the permanent impairment is, but once a doctor would project, once the claimant reaches maximum medical improvement.
But what I'm asking you is, what was the purpose then of that provision that the legislature put in? Does it have, if it's not given some meaning, and we assume that the legislature is not going to put a useless provision in, especially in the workers' comp law, which has been heavily lobbied and considered over the years. So if it's not that, what's the purpose of this?
The purpose is for impairment benefits, and as you'll see, it is under a different statute
So
section.
he does get, okay, so after 104 weeks, what was his impairment rating 6 weeks before that the judge accepted?
At that point, he was actually, because people can come out of maximum medical improvement because it's what a doctor opines, and if they go further for surgery. Originally, in March 2011, he had a 12% impairment rating. So we did pay out impairment benefits. You either get impairment benefits or permanent total disability benefits. You don't get the same.
What is the impairment benefits after 104 weeks? What is the amount?
It depends on what the doctor projects.
Well, what
your
in this
impairment.
case was it?
It was 12% at that time, and then it became in litigation about what the permanent total disability benefits were.
So although there's a gap, there's actually not a discontinuation of benefits?
That's correct. In usual cases, if there is 104 weeks exhaustion of the temporary benefits, but they're not at maximum medical improvement, they can get impairment benefits based on whatever the rating the doctor gives them.
So isn't that an important, I mean, from your point of view and the constitutional issue, and I sort of saw that in there, but from a practical point of view, can you tell us in this case what it meant at 104 weeks, what was he getting per week, and then with the 12%, what did he then get?
At this point, with this particular case, he did not get anything because what happened is that he was at the 104 weeks during the litigation. We had some dispute on whether or not he was temporarily totally disabled. So what we had in this case is that...
You just cut him off?
No, at the time we paid out his impairment benefits at the time he reached the original MMI, which was a 12% impairment rating, which came out to a certain amount of benefits that he got. It's not the full benefits he would have got under PTD, but it still was something that he would have received.
Well, now, let's break this down in numbers. In dollars, what are we talking about, this 12% versus what he would have gotten otherwise? How much are we talking about? You're saying 12% of what?
It's the loss of the...
I know, but just give me a number. What does 12% equal in terms of dollars?
I'm not too sure what the exact dollar figure is. It's not...
Give me a ballpark.
I honestly don't have that information. I know that it's not as much as he would get under the temporary total disability.
How much do we get for the temporary
They
total?
get 66 2/3 of their average weekly wage. I believe he got $765
okay.
biweekly.
And 12%, he would get 12% of what does that mean?
That just goes to a percentage rating, what they allocate.
I understand, but how much does that equate into dollars? I mean, can he live off of that?
I don't know if he would necessarily be able to live off of that, but he was also receiving during that gap period of time. It wasn't like he was out in the cold. He was receiving Social Security disability benefits.
That's from the feds, right?
Disability benefits. Right.
All right.
But with in this particular case, he was also receiving $16,000 during that gap as a result of a settlement with the temporary total disability benefits that we had. But
This is, you didn't pay him what he thought he should get in temporary total disability, and actually, this was the settlement of the difference that you were
correct,
paying.
correct. That was a
So
settlement.
this was really his benefit for those 104 weeks, the 16,000, right?
Right.
Okay.
You spoke earlier about the statute provides for, I guess, it could be called a projected disability rating once he reaches MMI. That's what you're saying, isn't it? That the statute provides that the treating physician can project what the disability rating will be once the person reaches MMI sometime in the future. All right. Now, are doctors able to do that in every case?
In every case?
Yes.
Yes.
Are there in every single case, the doctor can say once the 104 weeks runs out, or is about to run out 6 weeks before, the doctor can project that a disability rating will be whatever.
Yeah, but not at the time of the 104 weeks. They're projecting it whenever he reaches MMI, which is set forth in the statute. And I think the focus really needs to be on that this case is about permanent total disability, which is a separate section of the statutes than temporary total disability.
My focus is in instances in which doctors cannot make that projection, what choices does the person have?
Well, he had a choice because in the Hadley Court decision in Bonk, that was only 2 years prior to this Westphal 2 decision, they created the Oswald exception that a claimant can prove if they're not at maximum medical improvement as defined in the statute, if they have a doctor to say that, and if they're exhausted 104 weeks, if they have a doctor say that even if they reach MMI, that they would be totally disabled, then they can assert a claim for PTD and get awarded PTD benefits.
But isn't that, and that's what you would advocate in this case, but that Hadley was the correct interpretation?
Correct.
But where did they come up with that one, where that even though the legislature says MMI is what is the trigger for whether he's permanently disabled or not, that it can be opined, earlier than the date of MMI.
I believe the Hadley Court looked at the permanent impairment statute and said there was projections that way to provide for an impairment rating once they reach MMI, so that they also look the same way to here to be consistent with the statute. I think that the court, if they answer the certified question in the positive, what they're doing is essentially rewriting the statutes. And again, if we're focusing on the gap in benefits, that Oswald exception ameliorates the gap. It remedies that.
The Hadley rule is what Judge Benton relied on in his opinion, right? His separate opinion?
It was a few of the justices relied on it.
Well, he talked about that particular rule. Do you support Judge Benton's position?
A part of it, I don't support the position where he says that they should be awarded permanent total disability benefits, because I believe this case really is about PTD and whether or not Mr. Westphal met his burden of proof that if he's not at maximum medical improvement, whether or not he had showed that he was totally disabled once he reached MMI.
You don't think the facts in this case support the analysis in his opinion, is that right?
Right. As far as the facts in this case, it was similar to the Hadley decision, that you had a claimant that had exhausted his 104 weeks, that was totally disabled at that period of time by his authorized treating doctor, but it was too speculative to figure out what his work status or MMI or work restrictions were going to be once he reached, when the doctor is saying he's going to be as good as he's going to get. We had the same thing here in Westphal, and Westphal had brought evidence of his IME doctor to the JCC, as well as the JCC heard testimony of Dr. McCaleb, the authorized treating physician, and as the fact finder, he weighed the evidence and determined that Dr. McCaleb was more persuasive, and it said that in his final order that as the one who most recently did his surgery, I choose to rely on Dr. McCaleb.
You're out of time.
Okay.
Thank you.
Good morning, and may it please the Court. I'm Alan Windsor on behalf of the Attorney General. Case is here on a certified question from the First District, and the Court does have the benefit of complete agreement among the parties about what the right interpretation is.
And then we have like 5 different choices, none of which, and I assume you like choice Weatherall.
Well, we like the choice that upholds the statute, and that we agree with Judge Wetherell's interpretation. We agree with the interpretation that the district court embraced 15 years ago in Oswald and reaffirmed in the Hadley decision
There was a
2 years ago.
lot of controversy among the judges because they had had an unbroken precedent since Oswald Hadley. But just to make sure, this is the first time this court is looking at the constitutionality of the workers' compensation statute under the, what year was this passed?
The most recent amendments were 2003. The amendment at issue here was 1993.
So we really have, so we had the first district deciding all these issues. Were there constitutional challenges prior to this present one?
The first district didn't consider the constitutionality of this statute. So we had the panel decision did, but the panel decision is not in front of this court.
No, what
That
I'm
was
asking
vacated.
before that, because precedent obviously is a big issue for the first district, but for this court, even though the law went into effect in 1993, the way that this it's set up, where the first district essentially has plenary power over the workers' comp, unless they hold something unconstitutional or certify a question, we don't get a chance to look at it. Is that correct?
That's right. That's
Okay.
right. This is the first time this issue is in front of this court. Certainly, this court is not bound by Hadley or any of the other first district decisions, but we do believe that decision is the correct interpretation.
With the Oswald exception.
Yes, Your Honor.
So what is, when you said about what you like, Justice Polston, what about what Judge Benton said, that this plaintiff actually qualified for the Oswald exception?
Well, if there was a dispute of fact below, and we take no position with respect to the facts of this case, and what Judge Thomas said, and Judge Benton followed on a little bit differently, but what Judge Thomas said is that he did qualify because he was permanently disabled all along. And even under the prior interpretation from Oswald, if that were the case, if that were the finding, then he would have been entitled to permanent disability at the expiration of temporary disability because he did have a permanent disability. The problem with the new interpretation is it affords permanent disability benefits to people who do not have permanent disabilities. What the statute that provides the permanent disability benefits says this is for people who have been adjudged to have permanent disabilities. If once you improve, you are not permanently disabled, then you are not permanently disabled. And so that's the problem with the interpretation in front of this court, the Westphal majority interpretation.
But isn't the problem still, this is a person, again, we're not, not talking about somebody that had a neck sprain or, was faking it. We're talking about someone that had a significant injury, and yet because the doctor was optimistic that maybe he could get somewhat better. But how, in terms of it, in terms of his denial of access to the courts, how is it not, after the cut off the 104 weeks, he has no option to get any more of either temporary benefits or permanent benefits? And that's really what we're talking about. So explain how that's not unconstitutional under our previous case law.
Well, first, he does have the permanent impairment as another option that the statute provides
But
for, and that's
now
not an
maybe
issue
you
here.
can tell us. So that's the
Sure.
12%. Is
Well,
that the 12%?
that was my understanding is that was the finding here. But what the statute provides is
But
that
it's much less. It's certainly much less than, even though this guy was on 104 weeks, was as bad as he was at 105 weeks. He gets some other type of benefit.
But there was a fact finding in this case that it wasn't a permanent injury. And so to answer your question
I
about
don't think there was ever that he wasn't.
that he hadn't proven a permanent injury, that was the JCC's
I thought
finding.
it was that it was too soon to tell.
But that's right.
Well, that's a pretty big difference. I mean, if this was a personal injury case, believe me, this guy would have he might not be where he could never work again, but he would be significantly disabled for future pain and suffering, past pain and suffering, medical benefits, and the like.
There are limits in the workers' compensation statute, as there always have been. And you asked about the constitutional challenge, and there has never been, under Kluger or under access to courts, some abstract idea of what's adequate. The Kluger analysis goes to a comparison of what was available statutorily or under the common law in 1968, and it compares to what's available now. And it asks whether the legislature has abolished that cause of action. And so the easiest way to resolve the constitutional claim in this case is to recognize that he received more benefits under the current statute than he would have in 1968.
I'm a little puzzled by your statement that the law has never contemplated adequacy of remedy. Did I hear you say that?
In the Kluger test, which governs the access to courts in this type of claim, the analysis is that whether the legislature has abolished a cause of action that existed in 1968. That's what the court said in Kluger.
The question is whether there's an adequate alternative remedy. That's the Kluger standard.
Well, if the court has abolished it, then that's the next question. But the first question is whether they've abolished the cause of action.
But part of that question, part of the inquiry is whether there's an adequate alternative remedy.
That's the next inquiry, Your Honor. So if you do find that the legislature did abolish...
Just any remedy, though, still calls into question the adequacy of the remedy. I'm in total disagreement with your statement of what the law is.
What the law is if the legislature abolishes a cause of action, it must
or partially destroys it.
Then it must provide an adequate alternative.
All right.
And so first you look at what he would have had in 1968. And the petitioner talks about weeks in the abstract. I would have had this many weeks and now only have this many weeks. But dollars is the measure of recovery. And in 1968, he would have had up to 350 weeks at $49 per week. Now, applying the $765 per week limit that prevails today, the total number of dollars is some tenfold. And even if you apply
okay, so you're saying that it is an adequate alternative remedy, not that you do not look to whether it is or not.
Well, if the court were to believe that the court has the reduction from 350 to 104 is the abolition or the limitation of a remedy, then certainly it would be an adequate substitute. So I think there's two ways of looking at it.
Right.
Yes, Your Honor. I mean, when the legislature changes the law but provides an adequate remedy, then there is no Kluger violation.
Right. I mean, but that's the analysis, is whether whether it's adequate. But,
even if the court believes it's unfair.
What if you have to get there? You know, to me, this seems like the classic example of each of these well-qualified, articulate, and excellent judges all saying that my interpretation is correct. And I'm not rewriting, I'm just interpreting, but the way the other guy interprets is a rewriting.
That's right. Now,
that's exactly what we run into, is that number of judges, everybody's going like this.
Obviously, the court has an obligation to interpret it in accord with legislative intent, and there was some disagreement, a very close disagreement in the district court about what the proper legislative intent was. So all this talk about violating separation of powers and all this is just another way of saying the court needs to interpret the statute correctly, and there's a disagreement about...
On access to courts.
Yes.
Do we have to, you said it's just what existed in 1968, but don't we have to go back to when workers' comp first abolished tort actions for workers, and look at that point, we said, well, they gave an adequate alternative. If it becomes so you say it's really still terrific what workers get, and I think there are a lot of workers that would disagree with you, and don't we need to, why do we just go to 1968, number one, and two, and if Mr. Westphal could not have sued in tort because it was his, he had lifted furniture, where is there, and this is sort of why is there an access to court issue to begin with? Because he couldn't have a lawsuit.
The answer, and I see I'm almost out of time, but the answer to the question is, in Eller versus Chauvin, this court held that the Kluger analysis is keyed off what was available common law or statutorily in 1968. We know in 1968 he had no tort remedy for the same reasons you just articulated. There's no finding of fault. There's a sovereign immunity defense. But what he did have in 1968 was a statutory right to temporary total disability benefits, just like he has today. The difference is he had more weeks in 1968, fewer dollars in 1968. And so whether you say that's not an abolition or whether you say it's an alteration but a reasonable substitute, either way, it satisfies Kluger, even if in the abstract it seems inadequate. And that's what this court has said in Mahoney and in Acton, that sometimes people will get less than maybe it seems like they should, but those are determinations for the legislature. And as you pointed out, Justice Pariente, it is a system that's filled with limitations, and there's not going to be the same kind of recovery there might be in a tort action, but The benefit is there is recovery for all workers who are injured in workplace accidents. And so we would ask the court to answer the certified question in the negative and reject the constitutional challenge.
Rebuttal.
You asked what was the purpose, and the purpose was to reduce benefits in order to reduce costs. Impairment benefits are minuscule, and it's taking the comp rate of 765 and reducing it by 25%. So we went from 765 to 422. That's the math. And for a lot, 2 weeks of compensation for each 1%. So he converts from temporary total disability at 104 weeks to a minuscule amount. They get a credit for it, but it's what did they do? They abolished compensation for loss of earnings and turned it into impairments at a minuscule amount. Everything is inadequate.
At the impairment rate, you can, how long can you stay on that? Or do you stay on it until you can demonstrate that you are, in fact, permanently I don't understand how.
Well, 5% rating would get him 10 weeks of compensation.
So it's a lump, it's just an amount. It's not like
a very small amount.
Okay, I don't think that was clear, at least for us. Okay,
now,
so whatever the impairment is, it's not a weekly thing until you get to.
It's a symbol. It's about all you can call it. Now, 104 weeks is 71% less than 350. That's enormous. Now, we're back to the same question. In all of the cases in the past in which you addressed the Kluger versus White analysis of workers' comp, the first thread right out for any change was we have full medical. And that's about saying, well, it's a good thing for other things. We have nothing good anymore. There's nothing left in it. It doesn't, the comparison is not to common law. The common law remedies had been abolished 100 years before that. When the people voted for access to courts, that's about what they knew the remedy for employees was. That had been already abolished decades and centuries, well, 1917. So that's not what they think employees are going to get. Now they know what employees get. They get the short end of the stick. That's what they get. It's
Mr.
totally inadequate.
The Attorney General makes the argument that in the constitutional analysis that under a Kluger analysis, that it does not absolutely, totally, and completely freeze all statutory type provisions for all time. And what is your response to that statement? He says, well, we have to understand that it can still be an adequate alternative remedy, even though there are adjustments to a statutory scheme that was in place at the time we began our analysis.
Two things. First of all, it was to reduce costs for a crisis that no longer exists and hasn't existed in this century. It's way down. But the reason why that's not the correct analysis is quite simply 1968 is what the people knew it to be. This isn't that anymore. And so long as it's completely inadequate compared to it, it doesn't matter. In Smith versus the Department of Insurance, what I'm asking you to do in that regard is exactly what you did, just by precedent, and it's common sense. If you go through any amendment, which in this instance is 93, and go in section by section by section, this is valid, this one's invalid, they're severable. Anything that's severable is invalid. You should, I know it's a job, but you should compare 68, according to Kluger versus White, with what it is today. And as you make that comparison, if this is inadequate, it goes. If it's adequate, it stays. And that's what the decision should be. And we ask you to make that decision. Apropos of yesterday's lines from movies, I'd like to finish with a line from Star Wars. You are my only hope. Thank you, Your Honor, for your time and attention. Thank you.